The following podcast is by Mr. Jim Koewler, elder law and special needs attorney, helping and protecting those who need long-term care. And welcome back, everyone, to Answers for Elders Radio, as we're talking about those important individuals that need to be there for us as we enter our aging years. Maybe we may not be able to speak for ourselves or may not be able to be competent to handle our own finances. And Jim and I just spent the first segment, for those of you that maybe have missed it, we talked about the power of attorney, both general and healthcare. And we are going to move into now which person is next, Jim.
We're going to talk about who needs to be named in your living will. Okay, now this is Ohio. These are state animals. Powers of attorney are, slight differences in the 50 states, although there's an attempt to make them uniform. I suspect living wills are very similar in the states, but but there may be some slight differences. So you have to figure out what's different in your state. So, because I'm going off Ohio. Okay. But in Ohio,
it looks very similar to in Washington, just so you know.
I suspect because they're all dealing with the same sort of issue. The carrying queen, Terry Schiavo. How do you make a decision when someone seems to have had their brain shut down on them? Yeah. But the body's kept alive by a respirator and feeding tube, etc. Is that what they want? And how do you decide? Okay. Well, a living will is a chance for someone who isn't yet, I hate to be harsh, but isn't yet brain dead, to say, if I am at some point, this is what I want to happen. Right. Now, a living will isn't used very often, okay, because we don't see this happen very often. But when we do, it's traumatic for everybody. Because if we don't have a way to make a decision on keep them alive, let them go, and we don't know what they wanted, it's really hard, because we're talking about letting someone die or keeping someone alive who has really no quality of life and no consciousness. Neither is a good choice. So I urge people to do a living will, but I'm not so fussy about them doing it as I am with healthcare and general powers of attorney. Because this is a hard decision for them to make.
I had to make it for my mother. Yeah.
And wasn't that horrible? Yeah.
I still wrestle with it I know intellectually I did the right thing, but I still, the magnitude of the decision that I had to make was very difficult.
And so that's why I urge people to do this, make the decision for themselves. Okay. But still, some people don't want to, because if I sign a living will, I'm going to have a traumatic brain injury tomorrow. That's not how it works.
You in Ohio have what's called a POLST form, which is Physician's Order of Life-Sustaining Treatment. Do you know what I'm talking about?
We have something like it, but I don't think we have the specific POLST form.
It's where you put on the refrigerator. You don't know, you don't have that.
Oh, here we call them do not resuscitate orders. Okay,
that's something that I thought of when you were talking about this, because
that's a different animal.
That's another thing of,
because there's no one named, at least here in Ohio, there's no one you need to name on a DNR.
Correct.
The DNR you don't. Is, I have a horrible health condition, and if I have a heart attack, don't resuscitate me.
Correct. That is exactly what that says. And it's a line, it's a bright neon green, at least here in Washington State.
And here we use necklaces and bracelets. I even heard of one person tattooing it on their chest. Wow. We're going to do CPR, open the chest. Oh, okay, don't do CPR. Yeah. The most common thing is someone who has something horrible like ALS or horrible, painful cancer. And if they happen to have a heart attack that ends their pain sooner, they at least are willing to accept that. Welcoming it's a different question, and everyone approaches it differently, but they're at least willing to accept that. And but that's a do not resuscitate order, and there's no one else named in that other than the physician who agrees with the decision. Okay. In a living will, they name someone who gets the unfortunate phone call that hi, this is Dr. Newman. It appears, we have Jim Koewler here. It appears that his brain is not functioning and doesn't seem to be getting oxygen to the brain, or no oxygen uptake in the brain. And this is so the person on the other end of the line receiving the call from Dr. Newman is the person named in the living will, and that's their job, is to receive that unfortunate phone call and let the other loved ones know.
Yeah.
However, all too often, granted, this doesn't happen, living wills aren't triggered very often, but when they are, if the family's already fighting, because that's what families do. Oh, I'm named the living will, I'm in charge now. Well, that's because they don't know the law and they haven't read the form. They just see their name there and assume they're in charge. But all they're in charge of is answering the phone.
Sure.
But you want someone, so you're likely to name your spouse first because that's the relationship. You've chosen that relationship. After that, I keep it aligned with the healthcare and general powers of attorney, which is name the person most likely to take you in should you need long-term care. And this has almost nothing to do with long-term care, but just as I, with the powers of attorney, wanted to give the likely caregiver the power to get help and choose help and pay for help. I don't want that watered down by having someone else name the living will and say, "Oh, now I'm in charge." Okay.
And the other thing that, just from a practical standpoint, if you're the quote unquote family caregiver, you're advocating for that person anyway. You know what their wishes would be, even if it isn't written down on paper. You have that.
But if it's not written down,
I know. But there are things that are not written down, Jim.
Right. Even if this person has authority to make the decision in the power of attorney, they may hesitate to do so because it's not really a care decision anymore.
Right.
And this is a traumatic decision. Either way you go, this is a traumatic decision.
It is.
Okay. But there also then there's apt to be pushback from others, because here in Ohio anyway, somebody can say, "Oh, mom told me she revoked that. She doesn't want that anymore." And now we're into a proof problem.
Yep.
And there's no way to avoid that. Okay. There's no way. There is a way to avoid that, but that would be eliminating all your children before you go brain dead. And you might want to, but don't involve me. But I like keeping this consistent with the people named in the powers of attorney to be the agents in the same order, just to avoid the "I'm in charge now" problem. Okay. Yeah. The Al Haig after Reagan got shot. "Oh, I'm in charge," even though he was like 8th in line. Yeah. And he just, he peed on it and marked his territory that he was in charge now. Okay. And he wasn't, but so to avoid that problem, I suggest naming the same person in the living will, same people in the living will, in the same order as in the powers of attorney, because they do kind of go hand in hand. Yeah. Okay. So let's now jump to the regular will, or the last will and testament. Okay. And naming your executor or administrator or whatever they call it in your state. Okay. Here it's executor. Administrator is for someone who doesn't have a will. But again, name the spouse first. And this is easy for the spouse to back out of if he or she doesn't want it. Okay. But name the spouse first, because it's simply the most likely one, because they're going to get most everything anyway in most situations. Okay. So just let them handle it. And they also, in many states, get paid for their service of being the executor. So fine, leave that with the spouse. Okay. If the spouse has passed away, or the person is single, or you're just putting a backup in case the spouse passes away before you do, then you need to look for someone who gets stuff done, meets deadlines, and doesn't knuckle under from pressure from the other heirs, or from any of the heirs. Okay, because I know you don't like an heir being I don't. An executor, and that makes a certain amount of sense. And I can go either way on that. Okay. And I'll give you a chance to explain your reasoning on that in a second.
That's okay. I love that you have
I like your reasoning. It's really good. Okay. But I still want to go to the other personality traits first, because an executor's job is to roll up the business affairs of the dead person's life.
Correct.
Okay. There's some sentimental questions, but the sentimental questions rarely involve assets that the court cares about unless there's a fight over those assets. Okay. Probate courts care about assets that have a paper trail because the probate court can fix the paper trail. The paper trail ended with the now dead person, and they can then regenerate it into a living person. Okay. Or charity or whatever, whatever's named in the will. Okay. But it's lots of forms, lots of opportunities for hearings to make sure no one complains about what the executor is going to do, lots of deadlines to get stuff done because the probate court wants to keep this moving. Okay. So you're just looking for very business-like, let's get it done, just fill out the stinking form, submit it on time person. Whether they have sentimental feelings toward you or not may not matter unless their sentiment is going to take away their business-like traits. Okay. If this is just, to quote Larry the Cable Guy, which I almost never do, just get her done. Okay. Because that's all this is.
Yeah.
Just push the thing through and get it done. And yes, there may be disputes that the executor has to at least take the first shot at. So that's why you want someone who does not knuckle under pressure. But otherwise, pressure or no pressure, just get the forms filled out and keep it moving.
Right.
Okay.
And I guess I approach it as more of a sentimental thing, because I think of it as who's going to make sure that my animals get rehomed to the right home? Who's the one that's going to take care of the things that I most care about, like my grandmother's, tea cart and all those
and
things.
I think that's still the person who's very businesslike and pushes it through.
Yeah.
Okay. But unless it is share 0001 of Ford Motor Company,
right?
No one has sentimental attachment to the Ford shares in the person's estate. It's the value of the Ford shares they care about. Okay. Perfect. But the sentimental stuff, the antique chair, the drawing that your great grandchild did in 6th grade, those may or may not lead to a fight, but the court generally doesn't care about them unless there's a fight over them.
Yeah. So we're going to talk in our next segment about trusts. That's a whole other thing. And you know what? I'm excited to hear what Jim has to say right after this, everyone.
State of Ohio residents, you have a friend to help you navigate long-term care while protecting your assets. You can reach Jim at www.protectingseniors.com or just email him at jkoewler-afe, that's jkoewler-afe at protectingseniors.com.